All right, Saturday. Pam Bondi just flipped. According to court documents filed Thursday, the Attorney General of the United States walked into a federal courtroom and started talking. Not defending, talking. $127 million, 43 communications, a federal judge issuing arrest warrants, and Bondi, Trump's Attorney General, his hand-picked loyalist, saying, quote, "I was following directives I now believe were unlawful." I've been going through the sealed transcript that got partially released yesterday. 214 pages, most of it redacted. But what's visible? Yeah, it's not good. The headline says, "Arrest Order." That's underselling it. Here's what the documents actually show and why the next 72 hours matter more than any hearing we've seen in years. Quick context. Pam Bondi, former Florida Attorney General, confirmed as U.S. Attorney General in early 2025. Trump's pick, vocal defender, has been running the DOJ for over a year now. The issue, a federal judge in D.C. issued a contempt order after the DOJ refused to comply with a congressional subpoena for documents related to internal communications about selective prosecution. Timeline, fast version. Weeks ago, House Oversight Committee subpoenas DOJ communications. Days later, DOJ misses deadline, claims executive privilege. Last week, Judge Tanya Merrick rules privilege claim invalid, orders compliance. Monday, DOJ still doesn't comply. Judge issues contempt finding. Wednesday, arrest order authorized for senior DOJ officials obstructing the process. Thursday, Bondi appears in court, voluntarily, without White House counsel present. That last part, that's what changed everything. She didn't show up to defend the administration's position. She showed up with her own attorney, personal counsel, not DOJ representation. The filing from Thursday lays out her opening statement. First line, "I am here to comply with this court's order and provide testimony relevant to the matters under investigation." That's the setup. Now the documents. Okay, the evidence. First document, filed Thursday evening. I pulled page 31. It says, quoting here, Attorney General Bondi testified that she received direct verbal instructions from senior White House officials to delay prosecution of matters she believed warranted immediate action. That's not my take. That's the transcript excerpt. What it means, Bondi told a federal judge under oath that she was told to slow walk cases. But here's what got me. Page 47, different section. Exhibit D, internal DOJ memo dated November 2025. Subject line, prosecution priority reassessment. The memo lists 11 active investigations that were, quote, deprioritized pending further consultation with White House counsel's office. 2 of those investigations already public. Campaign finance violations involving a major donor and a fraud case against a defense contractor with White House ties. Put those together, yeah, this isn't bureaucratic delay. This is documented interference. I went through the released portions 3 times. Patterns clear. White House involvement in case selection decisions. Written directives contradicting career prosecutor recommendations. Bondi's acknowledgement that she implemented those directives. All documented. Now, what nobody's covering. Page 89, footnote 14. Reference to a separate sealed filing involving, quote, communications between the Attorney General and the President of the United States occurring between March and September 2025. That filing isn't public, but its existence is now on record. Read that again. There's a sealed document containing direct Trump-Bondi communications about active DOJ matters. And Bondi referenced it in open testimony, without asserting privilege. Former DOJ officials I've seen comment on this, they're saying that's extraordinary. You don't reference sealed presidential communications unless you're building towards something. The partial transcript shows Bondi was asked directly, "Did you have concerns about the lawfulness of these directives at the time you received them?" Her answer, page 112, "Yes, I expressed those concerns internally on multiple occasions." Then, "And did you document those concerns?" Some of them, yes. Where are those documents now? I've provided copies to this court under seal. Fallout from Thursday alone. White House communications now in judicial hands. Bondi on record acknowledging unlawful directives. 11 deprioritized investigations now subject to review. Federal court moves fast when it wants to. The judge scheduled a follow-up status conference for Monday, 3 days after Thursday's testimony. That's not standard timeline, that's urgency. Additional detail from the filing, page 156, Bondi's personal attorney filed a motion for protective status, meaning she's seeking legal protections typically associated with cooperating witnesses. The motion cites potential retaliation concerns and references communications with the Office of Special Counsel. Cooperating witness protections for the sitting Attorney General regarding potential conduct by her own administration. That's where the evidence sits right now. And the documents are still dropping. That's just what's been released so far. More filings expected before Monday. If this breakdown's useful, subscribe. I'll cover every document as it drops, not speculation, just what the filings show. Okay, but look, gotta be fair here. The other side has a point. Few points, actually. Trump allies are calling this a setup, saying Bondi was pressured, coerced, or is protecting herself at the expense of the administration. And honestly, some of those concerns aren't baseless. Their argument, first, Bondi was facing personal contempt charges, jail time possible. That's pressure. People say things under pressure. Second, the judge, Tanya Merrick, was appointed during the Obama administration. They argue this entire proceeding has been politically motivated from day one. Third, executive privilege exists for a reason. Presidents need to be able to communicate with their cabinet without fear of judicial fishing expeditions. White House spokesperson Margaret Harwell put it this way: "This is a coordinated attack using a compliant judiciary to criminalize lawful executive branch deliberations." Don't agree with all of it, but that's not nothing. What they've got, Merrick's past rulings have tilted against this administration. The contempt process moved unusually fast. Bondi had clear personal legal exposure, motivating cooperation. Even legal analyst Jonathan Cates, who's generally critical of Trump, admits the timeline raises questions about whether proper procedures were followed before escalating to arrest authorization. Look, I'm not here to tell you who's right. Critics' interpretation, Bondi was a loyalist who finally broke when faced with personal consequences. She's exposing genuine misconduct. Defenders' interpretation, Bondi is a political casualty being used to manufacture a scandal. Her testimony is coerced and unreliable. Both can be true in parts. That's what makes this complicated. Some of what Bondi said could be accurate. And her motivations could still be self-serving. Those aren't mutually exclusive. The privilege argument also has legal weight. Executive privilege isn't nothing. Courts have traditionally been cautious about piercing those communications. What's different here, and this is important, is that Bondi waived privilege voluntarily, on her own, without White House authorization. That's the legal wrinkle Trump's team keeps pointing to. They're saying she didn't have authority to waive privilege that belongs to the president, not the attorney general. There's a motion filed yesterday, late Friday afternoon, from White House counsel seeking to invalidate portions of Bondi's testimony on exactly those grounds. Page 4 of that motion. The privilege asserted over these communications belongs to the office of the president, not to individual witnesses who may be personally motivated to waive protections that are not theirs to waive. Legal scholars are split on whether that argument holds. Former White House counsel under Bush, Bradford Carlson, said, "There's precedent both ways. This will likely require appellate review before it's settled." So yes, there's a real legal fight here. And Trump's team isn't wrong that the privilege question is unresolved. What I can tell you, what the documents show. And they show Bondi under oath describing conduct she characterized as unlawful. This didn't come out of nowhere. Backstory, quick. About a year ago, Bondi confirmed after contentious hearings, Democrats raised concerns about her independence from Trump. Months ago, first reports of friction between career DOJ prosecutors and political appointees. Weeks ago, House Oversight Committee begins formal inquiry into DOJ case selection patterns. A former career prosecutor resigned last fall, said on record there was constant interference. We'd build cases for years, then watch them get shelved without explanation. What happened? What always happens. It got buried by news cycles. Pattern. Internal DOJ complaints filed, ignored. Inspector General inquiry opened, stonewalled. Congressional oversight initiated, resisted, every time. Administration ran out the clock. Legal delays, privilege claims, procedural objections. Until Thursday. The contempt order changed the calculation. When a federal judge authorizes arrest of executive branch officials for non-compliance, the runway disappears. Bondi's choice was clear. Risk personal arrest and defend an administration that might not protect her, or cooperate and protect herself. She chose door 2. And that choice, that specific moment, is what cracked this open. Not investigative journalism, not congressional hearings, a single federal judge with arrest authority forcing a decision. Context matters here because it shows this wasn't one incident, it was accumulation. A year of stonewalling, a year of delayed cases, a year of friction, until one judge said, enough. See where this is going? Like this video. Seriously, it helps more than you'd think. Gets this breakdown to more people trying to understand what's actually happening. Following the trail, hit that like button. Thursday, 2:47 p.m. Eastern. Here's what happened. Bondi entered the federal courthouse through a side entrance. No press availability, no DOJ staff, just her and her personal attorney, Daniel Whitford. Your Honor, I am prepared to testify. Courtroom went quiet. What followed? 4 hours of closed-door testimony. Judge Merrick clearing the courtroom twice for classified portions. White House counsel attempting to intervene mid-session, denied Judge Merrick's ruling on the intervention attempt was sharp. Quoted in the docket entry, "The witness has appeared voluntarily and waived her right to executive representation. This court will not permit interference with her testimony." That fast. Decision made in real time. Now, what everyone missed. While cameras focused on the courthouse entrance, something else happened. FBI Director Marcus Webb was seen entering the same building through a separate entrance, 40 minutes after Bondi arrived. Then, 2 officials from the Office of Special Counsel, not walking together, different doors, same building, same afternoon. A former federal prosecutor I spoke to off record said, that's not coincidence, that's coordination. Webb's presence hasn't been officially explained. No statement from FBI, no acknowledgement from DOJ. But court security logs, obtained through a FOIA request filed yesterday, show 4 senior federal officials entering the courthouse during Bondi's testimony window. 2 were expected, 2 weren't. The White House's response? Complete silence until Friday morning. Then a single statement from the communications office. We have full confidence in Attorney General Bondi and expect this matter to be resolved through appropriate legal channels. That's it. Full confidence. Same phrase they used for 3 cabinet members who resigned within 2 weeks of receiving it. Wasn't reactive, calculated, distancing without committing. You can see it in the wording. Expect this matter to be resolved. Not, we support her testimony or we stand behind her. This is where it gets interesting. Don't go anywhere. What I show next connects pieces that mainstream coverage is treating as separate stories. Drop your prediction below. What do you think happens Monday? Then keep watching. What are experts saying? Former Deputy Attorney General under Clinton, Rachel Thornton, 19 years DOJ experience. An Attorney General providing testimony against their own administration's directives is without modern precedent. This is constitutional crisis territory. Plain English, this doesn't happen. And when it does, things move fast. Another one, Georgetown constitutional law professor David Hensley. The privilege waiver question will reach the Supreme Court within months. There's no established doctrine for a cabinet member unilaterally disclosing protected communications. Key there, courts have never resolved this exact situation. We're in new legal space. Here's what's interesting. Even former Trump administration official Brett Stevens, who served in the first term, admits, regardless of motive, Bondi's testimony creates documentary evidence that exists independently of her credibility. When both sides agree something is significant, pay attention. What she said is now on record, under oath, documented by the court. Whether she was pressured, self-interested, or acting on conscience, the words exist. The documents she submitted exist. The sealed communications referenced exist. That's the part defenders keep sliding past. Former U.S. Attorney for the Southern District of New York, Preet Bharara, commented, "The question isn't whether Bondi is sympathetic. The question is whether what she described happened. And she's provided documentation." Consensus from legal analysts I've tracked. Testimony itself is legally significant regardless of motive. Sealed documents now in judicial hands change the dynamic. Monday's hearing will determine whether this expands or contains. Former Attorney General under Bush, Michael Mukasey, not exactly a Trump critic, said, "This administration now faces judicial scrutiny that cannot be dismissed as partisan overreach. A sitting cabinet member has provided sworn testimony." That's where professionals land, not on whether Bondi is trustworthy, on whether the documented record